Hello, everyone, and welcome to today's webinar, What to Do When the Loved One Dies, a step-by-step guide. My name is Carol Mitso, and I'll be your moderator for today. I'm the Chief Operating Officer for Cunningham Legal, and I'm excited to be hosting our very first webinar today. I'm pleased to introduce today's speaker, Jim Cunningham. Jim is the CEO of Cunningham Legal, and we're an estate planning and trust administration law firm with 9 offices around California. And Jim has been presenting in front of live audiences for the last 20 years, so he's a pro at this. He's also a published author and is currently working on his second book. Today, he's going to share the legal steps you should take when a loved one dies. It's an emotional and overwhelming time, and it's nice to have some peace of mind and someone in your corner. Before I hand the mic over to Jim, I have a few little housekeeping items I want to cover in our presentation and something about the Zoom platform. So hopefully all of you can hear us. There's a chat icon to the right of your screen. So please send us a message from that little chat area if you're having any problems kind of connecting with us. We've got some people who can respond to you. And just a reminder, today's webinar will be available on demand after the live session, meaning we're recording it and can send it to you. So we'll send it to you an email with a link to the recording. We'll also be emailing you what we call a survivor's checklist. And that will help you identify what needs to be done when a loved one dies. Just a bonus email. We'd love to hear from you during today's presentation. Right now, all attendees are muted. But if you have a question for Jim, please feel free to just send it through the Q&A icon at any time during the presentation. And Jim will be answering most of your questions at the end of this session. We'll have a little special period. So if we don't get to your question during today's webinar, we'll be sure to follow up with you afterwards. Lastly, we're going to do a few polls during the presentation, and your participation is very much appreciated. So I'll launch a polling question, and you'll see a window pop up on your screen. And you just click your choice, whatever applies to you, and it will automatically re-register. So without further ado, I'd like to kick things off by welcoming our CEO, Jim Cunningham. Jim, over to you.
Carol, thank you so much for that warm introduction. I've been in practice now 25 years helping clients set up estate plans, typically with a living trust. And there are 8 kind of big steps that people oftentimes...
Some trouble hearing you.
Okay, some trouble hearing me. Okay. So let me start again. So I've been in practice 25 years, and what happens when somebody passes away or also becomes incapacitated? So what do you do if you have this thing called a living trust? And most people have that do estate planning in our firm, or with most competent lawyers, are going to do some form of a living trust as at least a foundation to their estate plan. So what we're going to do before we dive into the 8 important steps to take a look at, I do have to tell you guys something very, very important. I'm a lawyer. I'm talking. Hopefully you're listening. This does not constitute legal advice. This is purely information only, and legal advice is one-on-one with a lawyer. And that's not what we're doing here. We're just kind of hitting the highlights, kind of taking a 30,000-foot view on trust administration. So I'm going to start a very common question. Even clients, even pretty sophisticated clients, they ask me, Jim, I have this thing called the living trust. Can you remind me, what is this thing? Why did I pay you all this money to get this thing set up? Well, a living trust is a lot like a bucket. So you see the picture of a bucket here, which it's got some cash in it. So when mom and dad come in to our office, they set up a living trust, and a living trust is much like a bucket. Mom and dad put their assets into the living trust. So they'll put their house, and you sign a deed, and you put the property into the house. The bank accounts typically go in the living trust. Business interests go in the living trust. Some things don't go in the living trust, and that might be an automobile. It might also be a 401k or an IRA or life insurance or annuities, and we're going to cover those toward the end. But those things typically don't go into trust. And what's the trust for? Well, that trust is designed while mom and dad are alive to provide for mom and dad, right? Mom and dad are typically in control of the bucket. So imagine a couple of hands holding the bucket there. Mom and dad are in control, and they pay their bills from the trust, and they go on vacation, and mom buys a new lawnmower for dad, whatever it is, all these things that are in the trust are for mom and dad. And so we'll use this example, mom and dad. But when mom and dad die, that bucket, they stop being trustee, and a trustee is the person who's holding on to that bucket. When mom and dad die, that bucket is passed off to a successor trustee. Many times it's the kids, and a lot of times kids come in and they say, I'm totally lost, Jim. I don't even know where to start. So that's what we're going to talk about today. That whole process is called trust administration, or settling an estate.
Okay, perfect, Jim. Here's a good opportunity to launch our first poll. The first poll asks you to share a little bit about your situation, just so we know, kind of why you choose to join us on the webinar. So we will ask you if you lost a loved one in the past year, and if it was a spouse or a parent. So if you just kind of click on one of those, we'll just wait a moment and just click on whichever one applies to you.
So people would click, have you lost someone? So yes, and then you would click the other ones there.
Perfect. We've got some good things. We'll just wait another minute, a couple seconds. You guys are fast with this. This is good. Okay, great. So looks to me, we can kind of just launch this little, share the results. Okay, good. So we've got a number of people who haven't lost the last one last year. We're just here for information. Okay, sounds good.
Good. Well, you know what? This is such important information, and we got a few real surprises in here. So whenever I go over this with somebody, they always say, I didn't know that. Oh my goodness, that's wow. What great information. So we're going to cover the 8 steps that typically happen in handling a loved one's estate. Number 1, the absolute first step is we got to find out so this is when someone's passed away. What did mom and dad have? So what do we do? We're going to gather information on deeds. And what happens in California is a deed is signed and it's recorded at the recorder's office. So one quick way to find out there is a living trust is you can actually go to the recorder's office and pull the deed. And most competent lawyers are going to do that kind of at the get-go. So bank accounts, we need to gather the information on the bank accounts. Retirement accounts, life insurance, we'll talk about those. So we need to gather what are all the data. Now, something you need to be aware of and mindful of, bank statements typically are delivered on a monthly basis. So every month you're going to get a bank statement. Under federal law, advisory firms, so this is where you might have a mutual fund, they're only required to send a statement every 3 months. Now, some of you might get a statement every month, but the federal law says you only need to get a statement every 3 months. And with life insurance and annuities, many times those statements are only sent out once a year. So this is one reason that it does take time after somebody passes away. Oftentimes, the person who's in charge of handling everything kind of has to wait and see what comes in over the next 12 months or so. Very important to get birth certificates, death certificates, super important. Marriage certificates, believe it or not, sometimes you have to prove that you were married, and that's more in a probate context, but sometimes you have to prove that you're married. And a death certificate, people ask me, well, how many death certificates should I get? And oftentimes you'll hear the number 10. Well, that might be 9 too many, or it might not be enough. So it really depends on your situation. Typically, if you have it, you're going to need 1 death certificate for each piece of real property and 1 death certificate for each account. Sometimes you get those back, sometimes you don't. Credit card numbers, you want to lock those down. You want to get a hold of those. You don't want any fraudulent transactions happening. So that's, and we'll talk later about notifying people, but credit card numbers, you want to get a hold of those. Safe deposit box, very, very interesting. Did you know that the name on the safe deposit box determines who owns what's in the box? So if mom and dad have a safe deposit box and they say, gee, we want to add Johnny onto the safe deposit box. So they take Johnny down to the bank and he produces his photo ID, and mom and dad add Johnny to the safe deposit box. Then mom and dad die. Well, if there's $100,000 cash in there, Johnny gets that cash and he doesn't have to split that with his sister Sally. So it's very important to pay attention to that, who the title in the safe deposit box is. Many clients will try and put a safe deposit box into the living trust. Many banks are reluctant to do that. So something to think about. Also, digital assets. You know, it's really interesting. My son graduated from college last Friday, and we were taking photos, and my wife ended up posting a lot of those on Facebook and tagging people. And for those of you who use Facebook, you know what I'm talking about. And for those of you who don't, you probably should join Facebook just so you can keep track of your family. But what I've come to realize is a lot of people's lives are on these social media platforms, and Instagram and Facebook is a big one for younger people, Snapchat, although it's a different kind of format. But those are what we call digital assets. And did you know that when you sign the end user license agreement, you do not own that content? So when you go into Facebook and you post a photo, guess who owns that? Facebook owns it. So in order to take control of those digital assets, there's some planning that can be done. But we were talking about this earlier, Carol, and I thought, how cool would it be? I think it was my great-great-grandfather walked 60 miles to enlist in the Union Army during the Civil War. How cool would it be if he had a Facebook page and I could see all those people? So I think this is really a cool thing for posterity, and we're living in this really unprecedented time. But the point is, pay attention to digital assets because they are increasing in value, and in fact may be very, very important in your family. So step 2, we've talked about assets. What do you have? Well, sometimes people don't have anything, and there's a lot less to do, but most people will have assets. And so once we go through the inventory of the assets, we look at the estate plan. The first thing we look at are going to be the will and the trust. Now, the difference between a will and a trust: a will is it's a piece of paper that you sign. In order for it to be valid, a judge has to make an order, and that's called probate. And a living trust, the reason a living trust avoids probate is it's kind of like a super will. A living trust is kind of like a super will that avoids probate. So a lot of clients will choose to opt out of the very expensive process of probate and time-consuming process of probate in California, and they will plan with a living trust. A living trust has a few components. A living trust, like I said, is a bucket. There is a trustee. So while mom and dad are alive, mom and dad are the trustees. They're in control. When mom and dad die, they stop being trustee, right? They've passed away, they stop being trustee. So a successor trustee steps in. And it's very important that successor trustee is in charge of the assets, but those assets are not the successor trustee's own assets. They're held in a what we call a fiduciary capacity, or remember Fido, the name? I don't know if I've never seen a dog named Fido, but Fido is fidelis, it's fidelity. It is the trusted advisor. And the definition of a fiduciary is the trustee has to put the beneficiary's interest ahead of the trustee's own interest. Okay, so the trustee's there to administer the living trust for the beneficiary. And who are the beneficiaries? Those are the people who get the checks. Those are the people who get the inheritance, right? Funeral instructions can be in an estate plan. And now some of my clients have done what's called pre-need planning. That's where you go down to your local funeral home and you say, I want this type of casket and I want this type of cake and this type of music at my funeral. And you can actually prepay that, and you write a check, and that money goes to a special insurance company, not the funeral home, so that when you pass away, it's prepaid, it's pre-planned. And there's a long list of things that, as you can see, that people have to do when somebody passes away. And if you can pre-plan your funeral, many people opt to do that. Many people don't. And I will tell you, in my own personal family experience, dealing with the funeral can be extremely, it can be a flashpoint. It can cause a lot of conflict. So it's something that requires a bit of mindfulness, and someone's got to pay for it. And many times, one or two of the kids will have some assets and the other kids won't. And so that can create some conflict. But your funeral instructions can be in your estate plan. So when someone passes away and you don't know what to do, look in the estate plan. Our firm, we use a binder, typically a 3-ring binder for estate planning, and you can look in there. So personal effects, who gets your stuff? And that's going to be in the estate plan. Well, who gets grandma's china? Well, there might be a provision in there that says Sally gets grandma's china and, Johnny gets the tools or something. Special bequests, those are typically in a different section of the estate plan, a different section of the living trust. And what that says is I leave each grandchild $1,000, for example. That would be a special bequest. And that's going to appear in a slightly different area of the trust. So it's very important when going over the estate plan, you do need to read every page of it, because there may be some very important terms that aren't necessarily where you're looking.
Okay, so Jim, you introduced a couple of terms here. So our poll number 2, we are launching, and it's really to kind of help us understand from where you are all coming and why you're attending today's webinar. So you notice the options here. If you can just choose one of them. Are you a trustee? Are you a beneficiary? Maybe you're just here to learn. All of it is good. Just take a moment, click in. Looks like the numbers are getting in. Great.
It's like a horse race.
Yeah. Looks like we're pretty close between those just wanting on the line for some learning, and we actually have about 41% of you who are our trustees. So this is probably really helpful to you.
Excellent. Excellent. So step 3 in the trust administration process, and this is within the context of somebody passing away. I think that your poll is still up there. Anyway, this is typically within the context of somebody passing away. You need to determine the available cash. So what happens when somebody passes away? You're going to have the normal ongoing expenses, the power bill, the water bill, the gardener at the house. If you have rental property, you're still going to have expenses associated with the rental properties. Some expenses will go down, but you will have some other expenses. And you need to really come up with a budget and how are we going to pay for this stuff? Because remember, when mom and dad die, if they're getting Social Security or some other retirement, typically that stops. And so that income stops, but a lot of the expenses still continue on. And funeral expenses is a big one, right? If that's not prepaid, that can be a pretty big expenditure. And determine how, if you're the trustee, you're going to have expenses. How will you be reimbursed as trustee? And we'll talk a little bit more about accounting for that later, but that's also kind of thing, because you know what, a trustee, you're going to have some expenses associated with handling the winding up of an estate. Also, make sure you get what's called a taxpayer identification number. Now, mom and dad had Social Security numbers, and we'll use Johnny and Sally, the kids, as examples. They have Social Security numbers. But when Johnny and Sally are administering mom and dad's trust, they don't use any of those Social Security numbers. They actually go to the IRS, and they get something called the taxpayer identification number. And that's like a Social Security number for the trust, if that makes sense. So Johnny and Sally won't, because when you open a bank account, Carol, I don't know if you've opened a bank account recently, it's getting harder and harder. You're going to have to provide a taxpayer identification number to any institution where you open an account. And then you open a trust account. So that's how you handle it. It's typically a bank account at a banking institution. You go to XYZ Bank, Johnny and Sally as trustees, they open up this account and they deposit funds in there. And from that trust account, they pay the expenses of the administration of the estate. Step 4 is asset management. Trustees, as I mentioned, are what we call fiduciaries. The trustee has to put the trustee's interest before the beneficiaries. So trustees have to keep, number one, accurate records. Accurate records of what's in the trust. Well, we've got a house, we've got these 3 bank accounts, we have this brokerage account, and then they also have to keep track of all the money that comes in, also known as income, all the money that goes out, that's expenditures, and then they end up with a dollar amount at the end. And if you think about it, it looks a lot like a bank statement. So, every month I get a statement from my bank and it says what my beginning balance was, and then what all the deposits were and all the withdrawals and the ending balance. And if I look at all that, all those numbers are going to match. They're going to add up. That's called accounting, right? And that's part of the asset management process. A trustee has a statutory duty in the state of California to provide an accounting. Trust can waive the accounting sometimes, but many times a trustee must perform or must prepare a complete accounting. Certainly, the CPA or lawyer helping the trustee can assist with that. There's also something called an investment policy statement. Something you need to know is typically a trustee is 100% liable for anything that the trustee does or anything that the trustee doesn't do that the trustee should have done. Here's a case in point. If a trustee has XYZ stock when mom and dad pass away, and it takes a year to administer the estate, which is not uncommon, and that stock goes down 50% in value, so it's $100 a share and it goes down to $50 a share, that trustee is personally liable for the decrease in value of the assets unless the trustee prepares an investment policy statement. An investment policy statement says, we're going through this trust administration and our plan is to keep these assets in place. We're not going to sell them. That's a written statement. That's a written investment policy statement. And that tends to protect the trustee. Step 5, notifications. Well, Social Security generally is notified by the funeral home. So somebody passes away, typically the funeral home is going to make that call and they will let Social Security know. It's one of the many things that the funeral professionals do. One thing that's kind of annoying for many clients I've had in the past, the feedback I've gotten is mom or dad die toward the end of the month, and then Social Security is notified after that payment on the 3rd hits the account. So mom and dad die on the 29th of the month, and then Social Security is notified on the 10th of the following month. Well, guess what? Social Security is depositing that Social Security on the 3rd of the month, and they'll yank that back out of the account. And if you've already closed the account, then Social Security is going to be coming after the trustee because they're going to get their money. But you can reach Social Security at the number here on your screen. There are other agencies that might need to be contacted. My father-in-law is retired United States military. He was a career Air Force Chief Master Sergeant. When he passes away, my wife will notify DFAS, which is the agency that pays his retirement. So a lot of retirement things that you have to, whoever's paying you on a periodic basis, those people need to be contacted. Otherwise, they'll just keep depositing the money, right? And then you're going to have, this is just going to snowball. You're going to have a problem. So the other notifications are a little bit more legal technical in nature. Most states in the United States require that when a person dies, whether it's with a will or a trust, that the people who inherit without a will or a trust, these are called heirs, that's what that means, the people who would inherit in the absence of a will or a trust are entitled to some form of notification. And this is true in California. You have to send a notification to anyone who would inherit if there were no estate plan. So let's say mom and dad disinherited one of the 3 kids, that person's still going to get a notification, right? That mom and dad have passed away. In fact, they may get a notification that they're disinherited. You also have to notify the people who are beneficiaries of your estate plan. So these would be people who inherit from you. So in this case, it would be the grandkids, maybe the example I gave a while back, grandkids inheriting $1,000 each. They're going to get notified. In fact, anyone named in the trust, even if they're a trustee or a successor trustee, should be given notification. And that has different types of forms in terms of how you communicate that notification. But something to be aware of is, you just don't notify anyone, right? You actually have to do something. And something to be mindful of is, and this goes to addressing outstanding debts, where you see the trustee is 100% personally liable for everything. I mean that. The trustee is 100% personally liable for everything. And what we're going through here are ways that the trustee can mitigate the trustee's liability. And this is very, very important, very serious business. So I will just say on a high level, the sins of the father aren't passed on to the son, so to speak. So your debts do not pass to your children. So children do not inherit their parents' debts unless the child's a trustee and they don't do what they're supposed to do, right? Then you can be in trouble. So outstanding debts are not forgiven with the one exception. And what's the exception? Student loan debt. Believe it or not, it's non-dischargeable in bankruptcy. And it's my understanding that the government-sponsored student loans are forgiven at death, which is kind of strange. Anyway, so outstanding debts aren't forgiven. You got to pay those. So you gather up all the bills and bank statements. And the trustee not only is responsible for the ongoing expenses, but the trustee is responsible for paying bills that should be paid and not paying bills that should not be paid, if that makes sense, right? So you need to look at every bill as it comes, because you get this scam that someone might send you a scam invoice for $10,000 and the trustee goes, oh, okay, I'll pay it. Well, no, you gotta exercise some due diligence there and make sure that it's a legitimate debt. So remember, the trustee is 100% personally liable. By the way, the trustee and executor, but trustee for our purposes, is liable for income taxes. So if mom and dad, and this is pretty common, mom and dad haven't filed income taxes for 3 or 4 or 5 years, once you pick up this mantle of administering an estate, then you're 100% personally liable for those tax debts. And once you've made a distribution to a beneficiary, the trustee cannot sue that beneficiary to get money back under California law, unless there's a prior, it's called a refunding agreement. Unless there's a refunding agreement, the trustee can't go after the beneficiary to get the money.
Jim, before you move on, we had a question from Jerry, and Jerry is asking, do I need to pay my mom's outstanding credit card bills?
Ooh, good question. 2 schools of thought on this. Some people say, if I don't have to pay it, I'm not going to pay it. if I can somehow, I don't want to say weasel out of it, but I mean, in a broad term, most of our clients, they say, if my parents incurred the debt, I'm going to pay it. But sometimes there aren't enough assets to pay. And so in this case, the government is the number one creditor, IRS, they're going to stand first in line. And then you have the last illness and funeral expense creditors. You then also have what are called secured creditors. So secured creditor, if I buy a car and it's worth $10,000 and I have a $9,000 loan on it, that car is going to get sold and that $9,000 is going to go to the lender, and the $1,000 is left to pay the unsecured creditors. Well, if there's $2,000 in credit card debt and there's only $1,000 to pay the unsecured creditors, then you got to figure out who to pay and who not to pay, and that's where you work with your lawyer to figure that one out. But in the real world, many clients, they say, I just picked up the phone and told the credit card company that mom died, and they just wrote the credit card balance off. So, go figure. I don't know. Step number 7. Insurance and annuities. Okay, step 7 and step 8 involve taxes. And this is very, very important. As on a high level, life insurance, the death benefit on life insurance, there's no income tax on it. That's subject to a state tax, right? And that number is changing, right, as we speak. But there's no income tax on life insurance. Annuities are a little bit different. Here's the difference with an annuity. Let's say mom and dad, they put $100,000 into the annuity and it goes up to $500,000 in value. Mom and dad die and they name Johnny and Sally the beneficiary of the $500,000 annuity. Johnny and Sally, they can take the first $100,000 out and not pay any tax, but that extra $400,000 that comes out, that's going to be taxable as income to Johnny and Sally. So they each add $200,000 to their income for that particular year. A lot of people aren't aware of this. So if Johnny and Sally run out and spend the money, and then they find out they have a big tax bill, I got news for you folks. If you spend the money, you still owe the tax. So that can be an unwelcome surprise. Now, there are some planning strategies that are available, again, using a qualified CPA attorney and financial advisor, where Johnny and Sally, instead of taking that $400,000 all at once, Johnny and Sally can take that over a very long period of time. In fact, they can take it over their life expectancy. So instead of each taking out $200,000 in taxable income, maybe they're taking out $10,000 a year. So what that does is that defers the taxation and also reduces the overall taxation. So it's very important to pay attention to the taxes. So you want to pump the brakes a little bit when it comes to insurance and annuities. Gather the policy information. That's very important. And be sure to have your death. Obviously, you're going to have the death certificates, and then contact the life insurance company. Sometimes you call them. Sometimes you download a form on the internet and send it in, whatever it is. Typically, it's okay to call the insurance agent. Typically, there's an agent attached to the life insurance policy, and you'll see that on your annual statement, typically, whether it's an annuity or life insurance. So that's a good place to start. Step number 8, IRAs and 401ks. Again, IRAs and 401ks can be really tricky assets. And Carol, one of the things that when clients come in, they say, Jim, I realize there's this trust administration thing, and I'm the trustee, and there's 100% liability, and I have to send out these notifications, and there's this process I have to go through. But I just went down to the bank, and mom and dad had a $100,000 IRA, and I was the beneficiary. And I just asked them, what do I do with the IRA? They say, well, do you want the money? I said, sure. And so I just gave them my social security number and signed my name, and they gave me a check for $100,000. Well, what's the problem with that? The problem with that is you've just taken $100,000 out of an IRA, or the child has, and they're going to have to pay taxes on that. And a lot of people don't know this. In fact, 87% of the time, when a beneficiary inherits an IRA, they take all the money out within a year. There's a better way to do it. It's called an inherited IRA or a stretch IRA. And all that means is instead of taking all the money out at once, you take it out in little bits over your lifetime. Now, when somebody passes away and they have a spouse, typically the spouse will reach out to the employer's HR department because they'll know where their spouse is working, right? That's human resources, by the way, HR. They'll reach out to the HR department. My wife's passed away. Okay, well, here's the paperwork, and they kind of walk you through it. But when the client is retired, many times they will have an IRA. They'll roll the 401k over into an IRA, and then you go back not to the HR department, but to the financial service, the financial advisor, right? If there's a financial advisor. And the spouse can do a couple of things. Most spouses will do what's called a spousal rollover. All that means is that the deceased spouse, when he or she dies, the surviving spouse, so let's say dad dies and mom rolls the IRA over to her. Dad's passed away. Now mom owns the IRA as if that IRA was hers, right? So dad put money away in the 401k, and then dad passes away and leaves mom as the beneficiary of the IRA. So mom inherits that IRA and rolls it over. The benefit is you don't have minimum distributions until you're 70 on a spousal rollover. Different than an inherited IRA. When mom dies and leaves that IRA to Johnny, Johnny can take all the money out, but we highly recommend that you stretch that money out over their life expectancy to minimize taxes. You know, administering a loved one's estate can be overwhelming. And I'm thinking of my mother. And when my mom was 11, her mom died of cancer. And that was 1955. That was a very long time ago. And then a few years ago, my mom's dad passed away, about 20 years ago, actually. It's been quite a while. And when my grandfather passed away, I was talking to my mom, and she says, Jimmy, because that's what they call me. They said, Jimmy, I'm an orphan. So here's my mom saying, I'm an orphan now. It was overwhelming for her. It's a tremendous sense of loss, and it's going to be tough. Okay. Costly. There is an emotional cost to going through all of this stuff. This is not a business transaction. Many times it's a child or children who will be successor trustees, and a lot of emotions come out. It's tremendously emotionally taxing. That's what I've seen in the years that I've been practicing. I'm sure there's a dollar cost, right? There's a dollar amount, but at the end of the day, it seems that it's the emotional toll for many people. And frankly, it's time consuming. I met with a client years ago. She was in her early 70s, and she says, I've been named successor trustee on 3 different estates, and I've administered all of those estates. And I had to tell my sister, I don't want to do this anymore. I don't want to spend my remaining good years administering other people's estates. So don't underestimate the amount of time that it takes.